Hello students, welcome to KANISHKA IAS. Welcome to question to concept approach. In fact, I don't want to reveal the question in the first place. Rather, I would like to explain the significance of the first Constitution Amendment Act. Why first Constitution Amendment Act is so historical? Because the constitution makers with noble intentions have drafted this great constitution. In fact, in the words of the Granville Austin, Indian constitution is a social document. Generally, constitutions usually be political ones. You take the Western constitution, any constitution you try to understand, every constitution will be having some instrumental value. They are rather political rather than social. Okay, but Indian constitution is not just being political, it is also social. Why? The reason to call Indian constitution to be social document is that Indian constitution tries to establish the institutions not just for the usual governance, rather to radically restructure the society, okay, in terms of political, social and economic aspects. Why? Because according to Gandhiji, India does not just have the external enemy, rather we have various internal problems. In order to address these internal problems, definitely we need to have an effective constitution. That's why if you try to look at the preamble, it tries to define the justice to be social, economic and political. In other words, the very justice approach, justice as an approach, will try to address the historical disadvantages faced by the various communities in the country, various backward sections and backward classes in the country. You just understand there are various vulnerable sections, right from women, SCs, STs, even children are also vulnerable sections. Hence the constitution tried to make the mention about these elements in the society in order to correct the injustice they have suffered throughout the history. Hence the political institutions or the democratic institutions must strive hard to achieve the better opportunities for these sections, for these disadvantaged communities. For instance, SCs have faced historical discrimination, STs have faced alienation, women has faced suppression, children has faced exploitation. In order to address the concerns of these communities, there are various constitutional provisions mentioned, right from fundamental rights to directive principles of state policy. Okay, so that's why Supreme Court in SR Bommai held that both fundamental rights and DPSPs are very much important. They must be considered to be two wheels of the same cart. But however, after the enforcement of the constitution, certain glaring defects have seen the light of the day. Why? Because there were certain historical judgments which have shaped the popular perception regarding the constitution. And even politicians were under the utter fear that whether the constitution is able to achieve the stated objectives or not. In fact, the constitution came into enforcement right on January 26, 1950. But before that itself, there are certain instances, certain incidents which created the apprehensions in the minds of the constitution framers. In this particular video, we are going to talk three important judgments which have shaped the very foundations of the Indian constitution. Okay, so let us understand these three important cases. Okay, right? The important cases which have shaped the very foundations of the constitution, as I told you, is one is Ramesh Thapar versus State of Madras. Second one is Chempakam Dori Rajan versus State of Madras. And Kameshwar Singh versus State of Bihar. These are the three landmark cases which have created hurry and hasty among the Indian political system to make the amendment to the constitution. Right, let us get into what these cases are. Okay, let us discuss the first and foremost important case is Ramesh Thapar case. This Ramesh Thapar case is about freedom of speech and expression. Actually, there was a communist magazine called as Crossroads. This crossroads magazine was actually banned by the Madras state government because it was violating the public order. It was actually inciting offense. On the grounds of these two, this particular magazine was banned by the Madras state government. And the argument of the Madras state government was, the constitution has granted us the free speech and expression under Article 19 Clause 1 Subclause A. And this 19 Clause 1 Subclause A is the most important democratic foundations in the country. Without free speech and expression, without the propagation of ideas, there will be no value and worth for the democracy. And court also, the Supreme Court also has agreed with the argument of the petitioners and said that this particular 19 Clause 1 Subclause A is being violated because of the act called as Madras State Violation of Public Order Act of 1949. This act is said to have violated Article 19 Clause 1 Subclause A of the Constitution. And moreover, in fact, even there are reasonable restrictions provided under Article 19 Clause 2 of the Constitution. In the 19 Clause 2, at that point of time, there were no restrictions permissible under public order, incitement to offense. So it means in the original constitution, these terms were not present. Public order, incitement to offense, and along with that, friendly relation with the foreign state. This was also not present in the Article 19 Clause 2. So the outcome was this crossroads magazine, which was banned on account of Madras State Violation of Public Order Act of 1949, was actually invalidated by the judiciary. Okay, so in other words, the people have been given a free hand, okay, to speak and express their opinions despite they may violate the public order. So this has created the concern among the constitutional framers and even the representative institutions. Why? Because we can't give any free hand to the people which may violate the public order. So in other words, this particular case has exposed the lacunae on part of Article 19 Clause 2 of the Constitution. This is number one. The lacune on part of 19 Clause 2 of the Constitution has been exposed by this particular judgment. Then coming to the second case, okay, that is nothing but Kameshwar Singh versus State of Bihar. In this particular case, actually this is a case related to right to property. Okay, what happened in this particular case is the Supreme Court has examined whether the compensation that is given as a part of the land acquisition, is it justiciable or not? Okay, the Supreme Court said the compensation that is to be given out of any land acquisition or any land distribution policies or any part of the distributive justice, that must be reasonable and fair. So it means Supreme Court has emphasized reasonableness and fairness regarding the compensation that is given out of the Land Reforms Act. Because I told you the constitution has to ensure the implementation of the distributive justice. The distributive justice depends upon two aspects. One is opportunities, second one is resources. In order to ensure the distributive justice, you need to distribute opportunities as well as resources. So resources means all the material resources like land, properties, okay, factors of production, anything like that. Okay, those must be distributed among the people in order to address the inequality and to establish the egalitarian society. That was obstructed by this Kameshwar Singh case. Initially, this Kameshwar Singh case versus State of Bihar, which was heard initially by the High Court of Bihar. High Court of Bihar has actually invalidated all the land reforms acts which were enacted by the State of Bihar. But when the government has appealed to the Supreme Court said that yes, the land reforms are important, but the compensation that is given must be reasonable and fair. In other words, if any person does not get compensation on the reasonable level, or if there is no fair compensation, the individual can go to the Supreme Court or High Court, because at that point of time Article 31 was also fundamental rights, right? So in other words, the government got a blow from the court with respect to the right to property. Okay, on one hand, the public order was not considered to be reasonable restriction, and on the other hand, in the Kameshwar Singh case, the compensation was considered to be justifiable or justiciable right. Okay, so here the regulation was at the blow, and here the distributive justice was also at the blow. And third and the most important case here is, that is nothing but Champakam Dorairajan case. Champakam Dorairajan case. In Champakam Dorairajan case, what happened? The Madras government has implemented a communal GO. So why we are saying it is a communal GO? Because the reservation policy was implemented by distributing the seats in the educational institutions in such a way that every caste, every backward caste will be getting their own share of the seats in the medical colleges. Okay, so this has created the insecurity among the upper class people and upper caste people, especially Brahmins and other sections. And moreover, the argument of the petitioner in this case was, sir, Article 15, first of all, Article 14 talks about equality. Okay, equality before law. Article 15 and Article 16 are nothing but the extension of Article 14. So in other words, Article 15 and 16 must be implemented and enforced in the light of Article 14 of the Constitution. And within the Article 15 itself, there are three classes: Class 1, Class 2 and Class 3. Okay, Class 1 and Class 2 prohibit the discrimination. Okay, Class 1 by discrimination by the state must be prohibited, discrimination by society must be prohibited by Class 2, and Class 3 is about special provisions for women and children. Here, the idea was that Article 16, Class 4 has permitted reservation, but not Article 15. So in other words, according to the Constitution, the reservation policy were permissible under Article 16, Class 4, especially with respect to employment opportunities under the government. Employment opportunities under the government. Whereas under Article 15, such reservation provision was not made explicitly. So this was a convenient ground for the petitioner to argue that the reservations in the educational institutions is unconstitutional. Okay, and also that you understand, Alladi Krishnaswamy Iyer, who was also member of the Constituent Assembly, he was lawyer to Champakam Dorairajan. And what was argued further, Article 15 Class 2 is violated, that is Article 15 Class 1 is violated, Article 29 Class 2 is also violated. Article 29 Class 2 means no citizen of India shall be denied admission in any educational institution on the basis of race, religion, caste and language. Here, what is being permitted here? The caste is the criteria to give the reservation. So it means it is a violation of Article 29 Class 2. And 15 Class 1 says state shall not be discriminating the citizens on the basis of race, religion, caste, sex and place of birth. On these 5 grounds there shall not be discrimination. But what the reservation policy states, the reservation is possible on the basis of the caste. And but government has argued we are implementing the reservation. Government has argued we are implementing the reservation on the basis of Article 46 of the Constitution. Article 46 of the Constitution falls under DPSP. And Article 46 says promotion of the interests of the SCs, STs and other backward classes. Okay. And but Supreme Court noted that directive principles of state policy are non-justiciable in nature, whereas Article 15 Class 1 and 29 Class 2 are justiciable. So the protection is possible only for fundamental rights but not for DPSP. So hence the reservation policy of the Madras government has been cancelled or nullified by the Supreme Court. You understand? So what is the outcome here? The outcome is simply that the 3 judgments, okay, that is Kameshwar Singh case, Romesh Thapar case and also Champakam case have glaringly presented the defects in the Constitution. Okay, so these are completely going against the very intent of the constitutional makers, that is ensuring the welfare state or ensuring the conditions which will be providing equality of opportunities for all the sections of the people and also correcting the historical injustice regarding the vulnerable sections in the society. So for this reason, in order to address these particular glaring limitations of the Constitution, the first Constitution Amendment Act was enacted. Okay, the problem related to right to property, okay, was actually addressed by the insertion of Article 31A and 31B. Okay, 31A is about protection of the laws with respect to land acquisition, acquisition of estates and other properties, etc. 31B talks about insertion of a new schedule to the constitution, that is 9th schedule. So it means any law is enacted according to article 31A, if it is inserted into 9th schedule of the constitution, will be enjoying the immunity from the judicial review. Okay, and not only that, in the Ramesh Thapar case, where the public order, maintenance of the Public Order Act, which was enacted by the Madras government, which was actually invalidated by the Supreme Court, in order to provide the protection for the public order from being invalidated by the Supreme Court, the amendment was made to Article 19 Class 2 of the Constitution. In 19 Class 2, to provide judicial immunity from questioning such laws which are required to protect the public order, two terms have been added to Article 19 Class 2. One is public order, second one is incitement to offense. Okay, and apart from that, even the term reasonable restrictions was also added. Reasonable restrictions was also added. And moreover, even because that particular environment was charged with anti-Pakistani sentiment, so it was being exploited by certain sections. So for that reason, even friendly relation with the foreign states was also added to Article 19 Class 2, right? And moreover, out of the lesson learned from the Champakam case, the constitution makers, especially the government headed by Jawaharlal Nehru, okay, attempted to add 15 Class 4. Okay, so in other words, already there is a provision for the special provisions for women and children in the form of 15 Class 3. So additional measure was added by 15 Class 4. So it means the special provisions can be made by the state in the interest of the socially and educationally backward classes of citizens. So this is how these three judgments have reshaped the constitution by prompting the Government of India Parliament to enact the first Constitution Amendment Act and to ensure the distributive justice, that is distributive justice here is related to distribution of opportunities as well as material resources, and thus limiting the judicial review. Okay, right. And apart from these important changes, the changes were also brought with respect to Article 85, 87 and other articles also. So we'll be discussing the changes related to other articles in the next video, right? And in this context, we need to recall the question which was asked in the UPSC prelims 2023. The question was simply that which of the constitution amendment was enacted to overcome the interpretation of the judiciary with respect to the fundamental rights. The options that were given were First Amendment Act, 42nd Constitution Amendment Act, 44th Constitution Amendment Act, and fourth one 86th Constitution Amendment Act, right? So simply you understand which amendment act for the first time enacted to overcome the judicial interpretation of the fundamental rights. Ramesh Thapar case was related to interpretation of Article 19. Okay, Champakam case was related to Article 15 of the Constitution as well as Article 29 of the Constitution. And moreover, this Kameshwar Singh case is related to interpretation of the right to property. So these three cases are related to interpretation of the fundamental rights. So which Constitution Amendment Act was enacted for the first time? That is none other than First Constitution Amendment Act. I hope you all aspirants come to know how to understand the Supreme Court judgments and how to choose the right option. But the key point here is your ability to understand the Supreme Court judgments and the historical happenings with respect to the Indian Constitution is also very much important to choose the right answers in the preliminary examination. For more videos, please keep watching KANISHKA IAS. Thank you.